start.
Good evening. Thank you so much for joining us this evening. And this is a presentation of, I am thrilled with the Mass Bar Elder Law Education Program. And in May every year they come out and they do programs, and we were thrilled to have tonight's program as part of our Aging in Wayland initiative. I don't know how many of you were able to attend our program, our vendor expo at the high school in April, where we had over 30 vendors, and it really presented a lot of opportunities for people to see what the options were that could make your life more comfortable, added quality, and safe. So we had Best Buy there with smart home technology. It was just terrific. So we're looking to look at a lot of areas, and tonight it's legal. So from the Mass Bar Association, we have with us tonight Attorney James Tabner. And I think we should just get started, and please welcome Attorney Tabner.
Thank you.
I will ask that you hold your questions till the end. I think that would be really helpful in getting through all the information that you need to.
Sure. Can everyone hear me? Is this is on?
Yeah.
Okay. So my name is James Tabner. My office is in Concord, and I live in Acton. And the topic tonight is important questions as we age. There's going to be a PowerPoint presentation, and it's going to correspond with what you have at your seats. And so I'm going to begin. So about this program, it's by the Massachusetts Bar Association Elder Law Education Program. And as Julie pointed out, Law Day, it's a part of Law Day celebration. And I'm a volunteer, so here to try to help you with questions. This is not working, let's see.
When is Law Day?
May 1st, actually.
Oh, okay.
There we go, oops. Okay. So important questions as we age. What is elder law? What does an elder law attorney do? So elder law is kind of a general broad topic, a general broad area that covers different areas of elder law. In elder law, one of the things we're going to talk about are just kind of general topics, but there are lots of different areas. It might have to do with legal documents, might have to do with financial matters, might have to do with social matters, might have to do for healthcare matters. And that's what an elder law attorney does. An elder law attorney helps you understand what information is available, what questions, help to answer questions you might have. There we go, okay. So one of the first topics, I don't want to block over here, is essential estate planning documents and considerations. Wills, healthcare proxies, power of attorney, deeds with a life estate, realty trusts, revocable, irrevocable trusts, gift plans, asset protection plans. Just by a show of hands, are people familiar with these documents? Do people have these documents, generally speaking? People do, okay. Wills, as you know, and trusts generally address what happens when you pass away, where your assets will go, who will be in charge of your estate, or who will be in charge of your trust. Anything that passes by way of a will is anything in your name alone. It has to be then administered by the probate court. A healthcare proxy is something that is effective during your lifetime. A healthcare proxy is an individual who you may delegate to make healthcare decisions for you. Before that individual can make healthcare decisions, an attending physician must certify that you are not able to make those decisions yourself. Unlike a power of attorney that is for financial matters, a power of attorney is effective right away. So if you execute a healthcare proxy, a physician has to say you're no longer able to make those decisions. Power of attorney, you execute one, whoever you give that power of attorney to can right away act on that power of attorney. So I think you need to be a little more careful picking a power of attorney, controlling the document, who has it, where it goes. Deeds with life estates and realty trusts. Frequently people reserve a life estate. By reserving a life estate, what that means is that you gift the real estate to someone, but you reserve a life estate, meaning that you reserve the opportunity and the right to live there during your lifetime. And on your death, it would pass to someone else. A realty trust is similar, except for, unlike a life estate, you can designate the number of years. You could say, I reserve this for 10 years, I reserve this for 20 years. Those are done for gift reasons. They're also done for Medicaid planning. We're going to talk a little bit more about Medicaid planning later on, but people do this in order to preserve assets for Medicaid. Revocable and irrevocable trusts. Revocable means you can revoke it, you can change it. Irrevocable means you can't. Irrevocable trusts, examples of irrevocable trusts are life insurance trusts, trusts, special need trusts, trusts for the benefit of minors or other disabled individuals. A transfer to an irrevocable trust is generally considered a gift. When you do that, the trust requires a trustee different than yourself. You have to obtain a tax identification number. You have to file income tax returns. It's similar to just making a gift, except for the difference is that you don't want that person to completely control the asset because of some of the reasons that I mentioned. Perhaps they're underage, perhaps they're disabled. There may be other reasons. Gift plans. Actually, I didn't talk about revocable trusts. Revocable trusts are trusts that you set up during your lifetime, and you use your own social security number. You're your trustee. You can control it. You can change it. You can alter it. You can amend it. That becomes irrevocable when you pass away. Frequently, people have revocable trusts, and they have it for estate planning reasons. Frequently, you see a husband and wife each execute a revocable trust, and on the first person's death, a certain portion passes over the second person's estate for tax planning reasons. Gift plans, $15,000 a year. Everyone in this room can give $15,000 of assets, cash, percentage of real estate, car, $15,000 without any gift tax. There's also a lifetime exclusion, which is currently $11,400,000 for federal purposes. Massachusetts is a little tricky. It doesn't have a gift tax. It has what's called a pullback, and that gets a little complicated. But as long as you make a federal gift, you're generally okay for Massachusetts. Asset protection plans. Frequently people set up different entities to protect their assets. They might set up a corporation. They might set up a limited liability company. Those are the kinds of things that protect your assets. We want to make sure that your personal assets are protected from any business you may have. So for instance, let's say you own a company and you also own real estate. You'd probably want to have the company in a corporation and have the real estate in a separate realty trust. Again, this protects your assets, your personal assets from these assets and those creditors. If I already have some of these documents, when and why should I review and update them? Well, there's many reasons why you should update them. Frequently what happens is people age, people pass away, so you want to take a look at who you've named as fiduciaries. Fiduciaries include personal representatives, executors, trustees. Those are all called fiduciaries. A fiduciary is someone who acts in a capacity for someone else, also called an agent, a representative. So frequently you have to take a look at who you've named. There's also a situation where about every 5 years, one of the most important things are power of attorneys and healthcare proxies. And if it gets to be roughly the 5-year mark, many banks, many financial institutions, many hospitals, many healthcare providers say, that's kind of old. I really want to see something more current. So about every 5 years, you should make sure that these documents are just current. Even if you say, I don't want to change anything, I'm happy the way it is, just call your attorney and say, can you just run me out a new set and just re-execute it? It's more current, and banks and hospitals are much more happy to accept those documents. If you switch residence to a different state, it's important to have those documents reviewed. If you have a child who is experiencing financial difficulties, maybe engaged in marital problems, you may say, gosh, I'm a little concerned about that person. I love my child. I want my child to share equally. However, this is what's going on in their life. So you can have special provisions inserted into your will, your trust, that says that if I should pass away, these assets will be held in trust. That will have an effect of helping to prevent those creditors from attaching those assets or becoming involved in a bad situation at the probate court as a result of a marital difficulty. What is the probate process? What does it mean to avoid probate? As I mentioned earlier, any asset that's in your name alone, in my name alone, in any of your name alone, if I die and I own an asset, I own a car, I own a bank account, I own a stock, I own a bond, if it's in my name, my will dictates what happens. And as a result, we're in Middlesex County here. The county seat is in Cambridge. So there's a probate court in Cambridge, and what you have to do is you have to file your will, file your death certificate, and file a probate petition and several other documents with the probate court. Now, in your will, you've appointed someone to be your personal representative. That person petitions the probate court, and that person will eventually be appointed the personal representative of your estate and be able to manage your assets, be able to pass out those assets to the beneficiaries, be able to pay bills, be able to make decisions regarding your assets. I don't know whether people, I'm sure you've seen newspaper legal advertisements in newspapers talking about the estate of so-and-so, and certain person has applied to become personal representative. That's another thing you have to do when you're petitioning the probate court. You also have to send letters off to the beneficiaries and the heirs. Now, beneficiaries and heirs are two different things. Heirs are people who are legally entitled to inherit. For instance, an heir is a spouse. An heir is a child. An heir could be a grandchild. Those people have legal rights to your assets. If you decide to not include those people in your estate, you would have beneficiaries that are different from your heirs. But you have to give notice to both heirs and beneficiaries, because people can't just exclude spouses or exclude beneficiaries or exclude heirs. There are rights. So both heirs and beneficiaries have to have notice. So that leads us to the next point. People try to avoid probate. And they try to avoid probate for the very reasons that I just mentioned. Number one, it's expensive. You have to prepare documents. You have to generally hire an attorney. You have to publish in the newspaper. This gets expensive. You then have to go into the probate court in Cambridge, which is public information. Anyone in the world can say, oh, Mr. Smith died, let's see what Mr. Smith's will says. You just say, may I see Mr. Smith's will? It's right there, and you can see who inherited the property. So if you want to avoid probate, frequently what people do is they put their assets in revocable trusts, and then a trustee can come in right away and just take over. And you don't even have to go through the probate court. You can also have assets held jointly. For instance, husband and wife, tenants by the entirety. One of the spouse passes away, the other spouse automatically inherits that. You can have joint tenants with rights of survivorship, which is the same as a tenant by the entirety, except for that applies to people that are not married. So if you're married, it's called tenant by the entirety. If you're not married, it's called a joint tenancy with rights of survivorship. If you have life insurance, if you have a 401k, if you have an individual retirement account, you can name beneficiaries. So if you have a specifically named beneficiary, you avoid the probate court. It automatically goes to your beneficiary. A lot of times people set up what's called payable on death accounts, termination on death, POD, TOD accounts. That's kind of a simple way of avoiding probate. What I would caution you is to make sure the bank will pay that out without an appointment from the probate court. Because a lot of times I've seen that people set up these accounts and the bank says, gosh, we still want to see something from the probate court. So remember that. If someone says, we'll just set up a TOD or a POD account, check with the bank, check with the financial institution. Make sure they'll honor it without a probate petition. Federal and state estate taxes, how do they differ from gift taxes? Well, as I mentioned earlier, federal government, $11.4 million for both estate and gift taxes. It's called a uniform transfer. So if you have $11.4 million, you can either give it away today or wait until you die to pass it away. An advantage of making a gift today is that it is presumably worth less today than it is tomorrow. So you would, if you transfer, you would also transfer out the appreciation. $1 worth today is worth more than $1 tomorrow. Actually less, I should say. $1 tomorrow is worth more. That's why there's an advantage of making gift transfers. Massachusetts does not have a gift tax. Massachusetts, for the last 20 years, has had a $1 million estate tax exemption, meaning if you have more than $1 million, you're going to pay a Massachusetts estate tax, potentially. Now, that includes everything that you might own. It includes houses, it includes bank accounts, it includes life insurance, it includes assets in a trust. Those are all part of the gift tax. But as I mentioned earlier, and we'll get into a little more detail, people frequently set up revocable trusts, and it's also called a bypass trust, meaning that you set up a trust and you can fund up to $1 million in that trust, and when the first person passes away, it bypasses the second person. So a husband and wife can potentially leave up to $2 million free of Massachusetts estate tax. When a person dies, when the first spouse dies, there's what's called an unlimited marital deduction. That's true both at the federal government and at the state government. I die, I leave everything to my spouse, no tax. The problem is I leave it outright via will. My spouse then has control of all my assets. When he or she dies, that's all included in the surviving spouse's estate. So if you use a bypass trust, that $1 million is not included in the survivor's estate because the survivor doesn't control those assets. it's controlled by the trustee and the trust. So that's how that's avoided. Gift taxes are obviously applied to transfers during your lifetime. Estate taxes is when you pass away. What is the difference between Medicaid and Medicare? Medicaid is commonly referred to in the Commonwealth of Massachusetts as Mass Health. Medicaid is actually federal government money from the federal government that is passed out to each state. Each state administers the federal money through Medicaid. They call it different things. Massachusetts is called Mass Health. Medicaid covers a number of things. There's Mass Health. Medicaid covers indigent people who can't afford health insurance. It also covers nursing home expenses, long-term care expenses. It also covers expenses for home health aides in certain instances. Also covers certain payments for disabled persons. Medicare is for anyone age 65 or older. It's a federal program as well. There are exceptions to that age 65, but generally anyone who's age 65 or older is automatically covered by Medicare. So up until that time, people generally have to buy private insurance. Once you reach 65, Medicare covers you. There are some Medicare situations where they cover some disability situations, but Medicare also covers an initial period in a nursing home. Might be 90 days, might be 120 days, just depending upon the circumstances. Nursing homes, long-term care facilities, you're either going to be a private pay person or you're going to be covered by Medicaid through Mass Health. We're going to get into a little more of that later on. There we go. If you need nursing home care but my spouse does not, will I still be eligible for Medicaid? The answer is maybe. In a situation like this, we divide the spouses up. We say there's a well spouse and a not well spouse. The not well spouse is the spouse who will require nursing home care. The well spouse is the spouse who lives outside of the nursing home and is still living at home. The application and qualification for Mass Health Medicaid financing for nursing homes, a well spouse can preserve certain assets. There's a certain amount of liquid assets that can be preserved. There's certain assets such as a home, such as an automobile, such as a small amount of life insurance that are called non-countable assets. So to answer your question, yes, you could be eligible, but there are certain limitations, certain requirements. Frequently people do Medicaid planning. They transfer assets to the well spouse. They transfer assets into irrevocable trusts, transfer assets into an annuity. Those would all allow you to qualify for Medicaid. Private pay nursing home runs $10,000, $12,000. The Medicaid amount is about half of that. If you apply for a nursing home, there's what's called a 5-year look back. And if you walk into a nursing home and say, I need a nursing home, I don't have any assets, they'll say to you, what's going on in your life in the last 5 years? What have you transferred? Those are brought back into the exclusion. If you apply for a nursing home and you're private pay initially, you run out of money, you can't be, for lack of a better word, thrown out, kicked out. You have to stay in that nursing home. The flip side of that is if you don't have assets and you're going through Mass Health, you will be pretty much told which nursing home you have to apply to, you have to qualify for. So it's generally a good idea to try to qualify for a nursing home with private funds initially. Who can see my medical information and how do I get it? Are there any exceptions, medical records? Can my medical records be disclosed without my permission? Who can see my medical information? How do I get it? Well, simply because you're a spouse does not give you any rights to anyone's medical records. My medical records are my medical records. Your medical records are your medical records. That's it. There's HIPAA rules. There's HIPAA protection rules. I can get any of my medical records. You can get any of your medical records. But that's pretty much where it stops. If you want to delegate someone to be able to obtain your medical records, you can execute a consent form, a HIPAA proxy, that would allow someone else to obtain those medical records. And again, as I said earlier, those should be frequently updated because people switch healthcare providers, people switch medical insurance plans, and people may look at it and say, well, this isn't new enough, we want a more current. So you can designate who can receive your records. Another exception would be, generally speaking, healthcare providers have rights to go back and forth. If you say to one healthcare provider, I authorize you to obtain all my medical records, which makes sense. I mean, let's say you have a medical situation, you want who's ever treating you to be able to go back in time, look at all your records, see if you had a similar symptoms last year, year before, 20 years ago. So that's also an exception. Can they be disclosed without my permission? No. There are exceptions for healthcare providers. There are certain exceptions in if you're ever involved in any litigation, involved in anything in court, you're sort of subject to your medical condition perhaps being put into evidence. That would be an exception. But generally speaking, your records are your records. What is a supplemental needs trust? Supplemental needs trust is a trust that's set up for an individual who is disabled, who is generally receiving government benefits. If let's say you have 3 children, let's say one child is disabled. Let's say that child is living in a group home that is being paid for by either federal funds or state funds, and everything's paid for. What you would do is have your estate split up into 3 ways, and the portion that you wanted your disabled child to go to, you would put in what's called supplemental needs language. And what that says is that I leave 1/3 of my assets to this child. However, I don't want those assets to disqualify my child for government benefits. So it's sort of trying to get the best of both worlds. I want my child's living comfortably, being paid for by the state or the federal government. If I should pass away, this money's available only if the government funds are not available. So for instance, there's situations where living in a group home, the government doesn't pay for certain things. They may not pay for hearing aids, they may not pay for visual aids, they may not pay for dental care, you might need a special kind of orthotic shoe. Those are the kinds of things that you would want a supplemental needs trust to be in place to be able to provide your loved one with these extras. There's also things, again, if you're living in a group home, there's funds that can be made available for group outings, other special privileges, but that's what a supplemental needs trust is. You can also do that during your lifetime. You can make gifts to a supplemental needs trust. You can set up a trust and say that here it is for my child, and if the government funds aren't adequately able to provide, I'm providing for these needs through this trust. What options do I have if I want to or need to sell my home? Reverse mortgages are a very popular item so that people don't have to sell their homes. Reverse mortgage is frequently when someone has paid off their mortgage, they own their home outright, they have all their equity in their home, and a reverse mortgage is similar to a line of credit. That allows a homeowner to stay longer in their home, they can pay their taxes, they can pay home health aides. And when you pass away, it's due. You have to either sell your home or somehow satisfy that mortgage. There's very strict federal regulations on reverse mortgages. There's a requirement that you go through counseling about this reverse mortgage. There's only certain people that deal with reverse mortgages. Over the years, there has been some fraud and abuse in that area. So if you're thinking about a reverse mortgage, be very careful, ask about counseling about it first. A home is not a countable asset for a nursing home. So for instance, if all you had was your home and you walked into a nursing home, say, I'm here, check me in, I have a home, you would qualify for mass health benefits. Your home is what's called a non-countable asset. So if you were to sell your home to pay for a nursing home, that right away becomes a countable asset. So you may want to not sell your home, and of course it may be recoverable after you die, but your home is preserved. You can also transfer your home for the benefit of a disabled child or a disabled person who's dependent upon you. That's also another option. But generally speaking, if you sell your home, that's countable assets. You want to try to avoid it if you want to be looking to qualify for a nursing home Medicaid situation. Let's see. Healthcare proxy. A healthcare proxy is if you designate someone to make healthcare decisions. Now, a healthcare decision is a very simple decision. It can be as easy as admitting to a hospital. It can be as easy as releasing from a hospital. The difference between a healthcare proxy and an advanced directive is similar like a do not resuscitate order, a do not intubate order, no feeding order. That's called an advanced directive because it's advanced. A healthcare proxy is just general healthcare decisions. Frequently, I've seen these situations, if people don't have advanced directives and they require an advanced situation, you either have to get a special court order or execute an advanced directive to make a somewhat advanced or complicated medical decision. A MOLST. A MOLST stands for a Medical Orders for Life-Sustaining Treatment. MOLSTs are something that have generally come into play in about the last 5 years. These are usually used in nursing homes. It's I don't know if anyone has a relative or a friend in a nursing home, has ever visited them and has seen a very bright pink paper in their chart or has even looked at their chart. A MOLST is generally on a very bright pink paper. And what that is a document that is intended to become effective when an emergency situation arrives. If an emergency medical technician has to transport someone, the MOLST will say exactly what that person wants. It's sort of a number of advanced directives put together in one comprehensive document. Now, a MOLST is completed by a primary care physician, done after a discussion with you and your family. So for instance, if you want a MOLST, for instance, if you want do not resuscitate order, that's a discussion. And it's an execution by both the physician saying, I've discussed this, and this is what they want, and then you sign off. So it's a very comprehensive, advanced, sophisticated document. That's why it's in this pink paper. It just sort of jumps out. Someone can quickly look at it, grab it, and they're ready to go. Who will make medical decisions if no health care proxy or MOLST exists? Very good question. It can become very complicated. What happens is that if there's no document in place, someone has to petition the probate court for what's called a guardianship. And a guardianship is an application to the court for permission to act on that person's behalf to make medical decisions. That can get somewhat complicated because generally speaking, what the court will do is appoint what's called a guardian ad litem. And a guardian ad litem is a person who tries to step into the person's shoes and say, what would this person want under these situations? And that's not always easy. That's why it's important to have, at the very least, a healthcare proxy in place. As you can imagine, filing a petition in the probate court, having a guardian ad litem appointed, it's very time consuming, it's very lengthy, and in the meantime, the person is in a healthcare limbo, and it can become very complicated and very emotional. What is a guardian? What powers does a guardian have? Guardianship is, as I mentioned earlier, if you don't have a healthcare proxy, if you don't have a MOLST, if you don't have an advanced directive, you need to petition for a guardian. Guardians are, generally speaking, the three categories of people who could have guardians are minors, disabled people, or people in advanced age who are not able to make their decisions. Who can petition to be a guardian? Generally speaking, anyone can, but it would probably be someone who is in close proximity by relationship. The powers, a guardian can have unlimited powers or limited powers. Many times, if people are taking what's called antipsychotic medication, which might be because of mental health issues, it might be because of advanced age, dementia, Alzheimer's. There was a case about almost 40 years ago at this point called the Rogers decision. In order to have a guardianship for antipsychotic medication, there are special safeguards and parameters in place that a court has to review: a healthcare treatment plan, powers of a guardian. As I mentioned earlier, all this is done through a probate court, and it's all done under the supervision of the court. A Rogers is done on an annual review. If you want to have a general petition, you have to make a case out for a general guardianship. You have to say to a judge, a probate court judge, this is why I want a full guardianship. Now, guardianship is different than a conservatorship, which might be the next slide. Nope, guardianship still continue. Specific medical decisions can a guardian make. If there's a healthcare proxy, that cannot, if the person who holds the healthcare proxy, that takes, and that's executed before a guardianship petition, that takes precedent. In a guardianship petition, if there's a healthcare proxy in place, that has to be revoked. There has to be a request in that guardianship petition to revoke that healthcare proxy. But it won't be revoked if the healthcare agent is not willing to give up that power. A guardian, again, a guardian, you can have a general guardianship, you can have a specific guardianship. I practice in a number of different areas. One of the areas I do practice in is guardianships, and frequently, if a person has a special healthcare situation, they may require a special operation. You have to file a specific petition to get authority for that specific situation, such as an operation. And it can be as simple as a tonsillectomy or an appendectomy, or it could be as complicated as, as strange as it sounds, the administration of electronic ECT is what it's called. Temporary guardianships are just as I mentioned. If there's a specific narrow situation that you need a guardianship for to make a special decision, that's a temporary situation. We need to have an operation. We need to have chemotherapy admitted. We need to go have a special test done. That's a temporary guardianship. Legal and financial decisions I will need to make. It's kind of a wide open, lots of legal and financial decisions. Legal decisions, we've talked about a lot of those. You're going to have to make legal decisions regarding execution of documents, legal decisions as to who you want to serve in these different fiduciary capacities, legal decisions whether to sell your home, gift your home, set up supplemental needs trusts, financial decisions, whether you want to protect your assets, whether you want to give away your assets. As I mentioned earlier, there's what's called a 5-year look back. Those are important financial decisions. Power of attorney, non-durable and durable power, and springing. I'll start out with the springing. A springing power of attorney is a power of attorney that only becomes effective upon a contingent event, meaning that it's not effective until this event takes place. Frequently in real estate sales and purchases, power of attorney, springing power of attorneys are used. So a springing power of attorney means that I'll execute a power of attorney when my house goes to sell, when my house goes to be purchased. I hereby authorized Ms. X to act on my behalf. But once that particular transaction is done, it's over with. Compare that with a durable power of attorney. So a durable power of attorney is a specific power of attorney that survives a person's disability, meaning that I execute a power of attorney today, I'm of sound mind, I'm competent, I'm able to do that. 10 years later, I'm no longer of sound mind, I'm not competent. My power of attorney is still legally effective. Keeping in mind that I recommended earlier that you re-execute every 5 years. But that's what's called the durable power of attorney. It survives any disability. Non-durable means it doesn't survive a disability. I highly recommend a durable power of attorney because a non-durable power of attorney has limitations, drawbacks, and it can create a lot of problems. Conservator. All right, a conservator is a person who is in charge of a person's finances. So if there's an individual who can't take care of themselves for whatever reason, you petition the court to become a guardian. If they can't take care of themselves, they might not be able to take care of their finances. You then petition the court to become a conservator. Anyone theoretically could become a conservator, but again, it's usually someone who has a relationship with that person, whether it's a relationship by blood relative, relationship by marriage, relationship just by the role in which you are. The conservator generally just takes over for that person to make financial decisions, to pay bills, to manage finances. There is a responsibility to annually account what your money has come in, your money's gone out. Frequently, a lot of times people have what's called a rep payee for Social Security. Frequently, if there's other benefits, such as benefits from the Veterans Administration or a pension, like a teacher's pension, sometimes people designate people to handle those finances. It's a similar. You have to do an annual reporting. You have to show where your money came in, where your money was spent. Temporary conservators. That's, again, a situation where, let's say a person suddenly inherits money or has to sell a house, buy a house. You would ask the court for emergency order, temporary order. When should I stop driving? Well, probably not tonight, because you probably all drove here, so don't stop driving tonight. That's a good question. And there's no one right or wrong answer. It's kind of up to an individual. There's no specific age requirement. There's no specific requirement at the Registry of Motor Vehicles. But the Registry of Motor Vehicles can at any time require anyone to take an eye test, to get an advice of a doctor, sign off on a medical certificate. The police have the power to revoke or suspend anyone's license at any time. That can be for any reason. And what they do is they send in a notice to the Registry of Motor Vehicles saying, we want you to temporarily suspend this person's license. It's a tough situation to give up driving, but I think it's important to think about other people. And if you ever receive a notice that the police have notified the Registry of Motor Vehicles that they think you should stop driving, it's probably a good idea. What if I incur unmanageable debt? Bankruptcy, give assets away. There's also credit counselors. There's also plans that you can enroll in that allow you to manage your debt, pay off your debt. Those are different options. I know the Bruins game starts at 8 o'clock, and this is going to roughly last an hour. So I can continue to go through the slides, or we can answer questions, whatever people want to do. If people have questions, I'm happy to take them right now. Yes,
I
ma'am.
have one. If your house is in a trust
Yes.
and all of your financial accounts have beneficiaries, but you have a car and you have personal items,
Yes.
do those personal items and car have to go through probate?
You still have to go through probate. So the question is, if the only assets, you have your assets in a trust, you've named beneficiaries, the only assets you have left are perhaps your car and some personal property. Generally speaking, no. The Registry of Motor Vehicles allows you to transfer an automobile to a surviving spouse with a death certificate. If you don't have a surviving spouse, then it gets a little more complicated. Personal property, the only time, if someone buying the personal property says, do you have court authority to transfer this? But personal property, legally, no. So it all depends upon what you're going to do with it, sell it, gift it. So the answer to your question is no, you don't have to go through probate. Yes, ma'am.
I have a question about the state of Massachusetts.
Yes.
I understand that if $1 more than $1 million is taxable, I believe it's 6.25%.
Yes, that's
What
true.
if it's a husband and wife?
Yes,
Is each spouse able to have $1 million?
that's correct.
So it's the asset, so in that case, when the second spouse dies, if the assets were under 2 million, they're not, the state of Massachusetts won't tax it, is that correct?
Well, it is correct, but in the example I gave earlier is that if, that's why you need a trust, is because the trust bypasses the second person's estate. So for instance, if you, let's say you had $2 million or $1.9 million, and you only had wills, or you had, if you named your spouse as a beneficiary, that spouse, when the first person dies, would have control of $2 million.
Right.
And then the first person didn't use their $1 million, they used their unlimited marital deduction. So a transfer to a spouse does not use the $1 million. The $1 million only applies to a transfer to anyone else.
That's not really my question.
Okay.
Then the second spouse
Yes,
dies.
yes,
In the state of Massachusetts,
Yes.
that pile of money was worth $2 million.
Yes.
And one person just died, even though that person was part of a couple.
Yep.
Is that $2 million now taxable?
it is taxable over $1 million.
Okay.
That's not true.
Right.
That's not true.
$1 over $1 million, supposedly everything is taxable at the rate.
Yeah.
Not just $1 or the $50 over or the $100 over, the whole thing is taxable.
I think that's what he's saying.
And that's not what he's saying.
Well, what I'm saying is that if in the example it was $2 million, that's subject to Massachusetts estate tax because it's over $1 million. You agree with that?
I agree with that.
Okay. So we're all in agreement on that because it's over $1 million.
It doesn't matter if it went from, you had that first exemption when the first person in the couple died, but the second, upon the death of the second spouse, anything over 1 million, they're not gonna do a look back and say, well, that came from another pile.
And any person who dies and controls more than $1 million, it's
Right.
taxable.
I understand.
And if you have, that's why if you have a husband and wife, you want to use a trust to put $1 million in,
Right.
and the surviving spouse is a beneficiary of that trust, but doesn't control that trust, then $2 million effectively passes tax-free because the first $1 million from the first spouse goes into the trust, and then the second spouse only has $1 million.
I understand. I have one other question,
Yeah, you agree with that? Everybody agree with that?
Well, the question is how much of it is taxable? All of it. All of it is taxable at the rate, not just that which is over $1 million.
Right.
Oh, I know my next question, I'm sorry to interrupt. I've been told things like Roth IRAs and certain kind of IRAs and retirement accounts can't be put in trust, is that correct? And houses, I don't know, that's why I'm here, I'm trying to learn, but I've heard that.
So you're saying, can you name a beneficiary of an IRA? Is that your question?
No, if you put an IRA or a Roth, 401ks, can they all go into a trust?
Well, a trust cannot own them because those are owned by people. People own pension plans, people own IRAs, people own 401ks. People do. They can own it. A trust can't own those assets.
So what can a trust own?
Well, you can name a trust a beneficiary of an IRA or a 401k.
So that's the way you could do it.
You can do that. The difficulty, that gets a little complicated. And the reason it gets complicated is because when you have, if you name a surviving spouse, you get an automatic rollover. It's tax-free. But if you name a trust, and a trust has several different beneficiaries, then it could become taxable because the spouse is only one of several beneficiaries of the IRA or the 401k.
I understand, but I would guess, and your expertise as far as it passes mine, often the spouse leaves everything to the surviving spouse, and then the situation comes to what happens when the second spouse is gone.
Well, let me give you an example of where you might want to use a trust. And I've seen this happen frequently. There's a lot of times people work for their entire career and a lot of their salary is put into deferred compensation, 401k, pension plans. So someone has $1 million pension plan or a $2 million pension plan. They have very few assets outside of that pension plan. So they don't have anything to fund that $1 million that we just talked about, the $1 million estate tax exemption. If they name the spouse, they aren't saving any estate taxes. If they name their trust, they can use that to fund their estate tax exemption, their $1 million estate tax. So in that case, you may want to do it, but again, that becomes a numbers game. You got to look at all the lives. You got to say, okay, well, if I do this, I'm going to save X dollars of estate tax, but what is that going to do for income taxes? Because other than my spouse is going to be a beneficiary of that trust. So it involves a kind of a number pushing, seeing tax comparisons.
I'm following you, I still kind of go back there, and I don't want to dominate the conversation, but it
Sure.
seems like many husbands and wives would just name the other, they're not gonna put their heirs yet.
Well,
As the beneficiary.
that's a matter of personal preference.
I understand.
But as I say, you might want to do it to fund your $1 million
Yes.
exemption. So that's one reason why you want to do it.
Thank you.
Yes, sir.
Is there a cap on the amount you can put into the supplemental needs trust?
11.4 million.
Okay.
I mean, that, your lifetime or your testamentary transfer.
So I can only put a small percentage of my personal wealth into it.
You know,
Just-
no, we tried, sure, exactly. You get it. That's true. Anyone else have any questions?
I have another one.
Yes, ma'am.
If you go into a nursing home
Yes,
and you have enough money to pay for the first 2 years,
yes.
when does the 5-year look-back period begin? When you go into the nursing home or when you've used up all your money?
So you're not applying for
Now, no.
Mass Health or Medicaid until after 2 years.
Right.
So that's when it's your 5-year look back, when you actually sit down and fill out your application.
Oh,
That's one of the questions in the application.
okay.
What's gone on financially the last 5 years? You've already got 2 accounted for.
Yeah, so
I
you-
lived in a nursing home, I
So
paid
they
for
go
it.
back to beyond the-
Exactly.
Oh, okay.
Yes, ma'am.
And maybe you can't answer this, but, say that you don't have any of the documents and, you know, we're married, no kids. What does it cost to get all the documents that you need? Oh, maybe you can't answer that.
Well,
Yeah,
hard to, I mean, it varies.
Yeah.
I've seen as little as $2,000 to as high as $20,000.
okay.
Just depending upon how sophisticated it is, whether you're going to a local person, whether you're going to a more sophisticated person, depends upon where their office is. It varies.
Okay.
Yes, sir.
Having a generic will for so many years with beneficiaries never changing, should it be updated?
I think it should be because when you say generic with beneficiaries never changing, were any of those beneficiaries ever minors at any point?
Then,
So
now they're all married.
now they're all married.
Still same.
Yeah.
It was done through an attorney. It's never changed in any way. It all goes to our ears in the chain. Should that be changed?
Well, have people moved?
Yes.
So you probably want to change it because usually you say so-and-so who lives at so-and-so, so that's an important thing. If you did it when your children were minors, you probably had guardians in there. That's no longer applicable. How many years ago did you do this? 50 years. I think I'd redo it. I think there's probably a few things that might have changed. And again, you're right.
I mean, their names have changed because they're married, but.
Well, that's also good. I mean, they were so-and-so Smith, but now they're so-and-so Jones. Well, it gets complicated. How do you know? So I would definitely.
Okay, thank you.
Yes, ma'am.
This will be a quick question. If somebody goes into a nursing home, they go to a nice one, and they're paying, how many months do you have to be there before you're no longer eligible to be thrown out because you ran out of money? You know, am I being clear? Medicaid kicks in at some point when you run out of money, but how long if you go for a week and you run out of money, they'll throw you out, I guess, but if you're there a year, how long do you need to pay for yourself and then
So,
have Medicaid kick in?
right, so
One last time.
facilities have rules. That,
Okay,
in other words,
so
they
what
say,
it is.
so again, as I discussed earlier, once you're in the door, you can't be asked to leave. But if you're not in the door, they don't have to admit you, and Mass Health will say, okay, we have an opening in Marlboro. And, well, gee, I live in Wayland, I want to be closer. Sorry, we're paying for it, we're going to designate where you go. Now, if you pay for it, I want to move into this place in Wayland, it's nice, I've got X number of years. You say to the facility, I've got X number of years
Of money,
of money. And they either say, you're in or you're not in.
I see.
And it's
So-
up to them.
Okay, it's up to the person.
It's up to them. Usually they require, I don't think it's 5 years, probably 3 years. And then you can apply to Mass Health, and then you'd have the same bed, you live on the same floor, but you would not be paying yourself.
Thank you.
Yes, you're welcome. Any other questions? Yes, ma'am.
What happens in the state of Massachusetts if a person dies and has no will and hasn't set up trusts?
So if a person dies with no will and they have assets, that's what's called dying intestate. And intestate means without a will. Testate means you have a will. Intestate means you don't have a will. So what intestate does is that there's a designated by statute way of inheriting property. And generally speaking, it goes down to your children, grandchildren. If you don't have children or grandchildren, it goes up if you have parents, and then it goes laterally, this way. If you have a spouse, the spouse has certain rights. Spouse doesn't inherit everything. The spouse has what's called a spousal share. So it gets pretty complicated because you haven't designated who you want to manage your estate. You haven't designated who you want to inherit your property. So there's lots of things to talk about, lots of things for a judge in the probate court to make decisions about, which might not be a good thing.
When you say sideways, do you mean siblings?
Siblings, yes. So it goes down, up, sideways, then that way,
Okay.
that. So, yes, sir.
With the exception of specific dollar amounts.
Yes.
Most states have the same rules, so that if you move from Massachusetts to New Hampshire or North Carolina or whatever, and pretty much depend on the documents you already have.
So as far as estate taxes are concerned, Massachusetts is one of the most taxable estate taxes in the country. Most states say that if you don't pay a federal tax, you're not going to pay a state tax. That is supposed to sunset in 2025 is the last year of that. And then after that, no one knows what's going to happen. So I don't know if people remember, I think it was 2010, there was no federal estate tax at all. As far as moving to another state and your documents, whether they're legally sufficient, I've, many times I've presented out-of-state documents to the probate court, and they've been fine. The problem that you run into is that Massachusetts has certain requirements for a will. You need to have 2 witnesses, you need to have everyone's signature notarized, you need to have a certain clause in there that says who you are, that you witnessed. And a will in a different state might not have that. So if someone wanted to contest that will, they could say, oh, look, it didn't have this. And if it didn't, that will might be thrown out. So it all depends upon whether it's contested or not.
If my understanding is correct, the U.S. Constitution makes a provision that each state must recognize the laws of the different states. So would that apply to inheritance and health proxies and all the rest?
Well, when you talk about the U.S. Constitution versus states' rights, it gets a little complicated. But states have delegated powers. This is a little constitutional law. States have what's called delegated powers. Anything that's not delegated to a state is left up to the federal government. So the federal government inherits power by virtue of default. Property rights are specifically delegated to individual states. Generally speaking, health, education, and welfare are what states. So anytime a state says, we're doing this, they do it because of health, education, and welfare. Welfare is a will. Welfare is leaving your property. So states make those decisions. So other states don't have to recognize it. If that makes sense. Any other questions? Okay, well, thank you. You've been a great audience. I appreciate it. And thank you very much.
Jim, could I just?
Yes. Oh, one more announcement.
This publication from the Mass Bar, it's the Elder Law Education Guide, is a phenomenal publication. What we have done is photocopied the section that Attorney Tabner spoke about tonight. But on your way out, there is one of these copies. If you're interested in learning more, the table of contents is in there. You could go on the Mass Bar website, or you could go on the Wayland COA website, go under useful links, click on Mass Bar, and it's all yours. Thank you so much for joining us tonight. Thank you, Attorney Tabner.
Thank you, Julie. You're welcome. Thank you all.